ROP.
Great. Hi, everyone, and welcome to the Women's Caucus, Vermont Legislative Women's Caucus. What is it today? March 27th. Confirmation is the 27th. My name is Angela Arsenault. I'm a representative from Williston, and I co-chair the Women's Caucus along with Representative Ella Chapin from East Montpelier. And we work in collaboration with Carrie Brown and the Vermont Commission on Women. We're really glad Carrie's here with us, as well as some commissioners here present today, and I think online perhaps.
Yeah.
And so we're gonna typically we'll do like a whole room introduction thing. We're not going to do that today, but just wanted to contextualize kind of who we are up here. And so I will say the idea for this particular meeting came out of an article in VT Digger back in January. It was the first time that I read about I don't know, we'll find out the proper term, policy, procedure, investigations involving pregnant women at DCF. So I had never heard of that before. Ella and I both really wanted to learn more and are grateful that we have Commissioner Winters and Deputy Commissioner Radke, as well as
Lindsay Barron.
Thank you. I'm sorry. I should have known that from DCF to share more about this practice. So Ella's going to frame up the conversation for us a little more specifically.
Yeah, thanks for everybody's in the room and online. We are going to record today's meeting because there are folks who would like to be here and hear more, couldn't be here at this busy lunch hour. We really do, I just want to second the appreciation for DCF's willingness to come and speak with our caucus today about this topic. We do want to just clarify, and I know we put this in the emails and other things, but this is not an opportunity to talk about the open case for lots of reasons that I think most people appreciate, but a really great opportunity given DCF's interest and willingness to talk with us about this, to understand just the background around policies and procedures at DCF and statutory authority, how it comes, where that comes from, and just for us to learn more, because right now a lot of us have just heard some news. So we look forward to the presentation they're going to share. It's about 20 to 30 minutes, and then we will definitely have at least 10 to 15 minutes for some Q&A. And just a reminder, please don't ask questions specific to the case, but other questions related to the presentation and to your general understanding will be welcome. And unless I missed anything.
Yeah, and I'll just say maybe I've seen the slides, and I think it seems like pretty much background information, a lot of like foundational information about DCF. So if it's possible to move through those pretty quickly and leave more than 10 minutes for questions, I think that would be great.
Thanks. Okay.
Have at it.
Thank you. Thank you very much. I really appreciate the opportunity to be here with some of my team to talk about this subject. And as was stated, we can't speak to specifics about the lawsuit, but we really appreciate the opportunity to talk about how DCF does its work more generally and be able to answer some questions that you might have at the end of this. We want to be as transparent as possible about how we go about the very serious work that DCF is doing every day, 7 days a week, 365 days a year. And I'm sorry, I should introduce myself. My name is Chris Winters. I'm the commissioner of the Department of Children and Families. I've been in this position for about 2 years. I'll start off with a few statements to set the table, and then I'll turn it over to the very capable experts who are here with me today. Vermont's really lucky to have these leaders in DCF. To my immediate left is Deputy Commissioner Erica Radke, who's been our deputy in Vermont for about 4 years now, and Lindsay Barron, who is DCF's Director of Policy and Planning. Who was recently promoted to that position after 13 years in other policy roles. I want to say it's my honor to be the commissioner of DCF and to have this time to tell you about our work. You'll hear from Lindsay and Erica in a moment. You'll see some materials, as Representative stated, very high level about our organizational structure, the legal structure we work within, who our partners are in this work, what structured decision-making looks like, the role of healthcare providers and the judiciary in some of the decisions we make, and how we go about this work with the goals of prevention, support, family reunification. And we'll also show you some data that's showing the declining numbers of children who are in DCF custody due to some really hard work that Erica and her team have been doing over the last several years. In this role, I'm the legal guardian of several hundred children under the state's care. And DCF also has that very solemn responsibility of receiving thousands of reports of potential abuse and neglect each year. And so we take that mission of protecting children and supporting families very seriously. And we work really hard to protect the safety of children while balancing the rights of parents. DCF's family service workers have some of the most difficult jobs in state government. It's the hardest work with the highest stakes. They have to make life-changing and sometimes life-saving decisions every single day to make sure children are safe from abuse and neglect. I often have people come up to me randomly in the hallway and say, "You have the worst job in state government. You have the hardest job in state government." But I can tell you the DCF workers who are on the front lines working with families are the real heroes. They keep coming back to work every single day to continue making a difference after facing some really difficult, emotionally burdensome situations. I have so much appreciation and respect for the work that they do. As you might have noticed, DCF tends to be in the news when things go wrong, and we can be criticized from all angles. Sometimes we're called out for not doing enough. And then in the next moment, we might be called out for doing too much. It's a really difficult balance to strike that right action and to do our work. And sometimes we make mistakes. We'll own up to those. We make mistakes in working with thousands of complex family situations every single year. We have to own those mistakes. We have to be accountable. We have to improve from them. We have to do better when we do make mistakes. I don't shy away from that. And there are obviously times when that criticism and that scrutiny is deserved, and other times when it's not. Sometimes that criticism is unfair and it's uninformed, and we can't respond to it due to our obligations to protect the confidentiality of the people we are serving. So the stakes are high. Now I say this to set the table to let you all know what I think is obvious, that the stakes are high and the pressure is immense on our workers. In every state, family service workers, the vast majority of whom are women, suffer from high turnover rates, 30% or more in most states, due to the difficulty of this job, due to low morale, and due to burnout. We're working really hard at DCF to try to counter that with our workforce initiatives on recruitment and retention. And part of that is making sure that our team knows that they are valued, they're appreciated, and that their work is making a difference. That's one of the reasons of many that we appreciate the opportunity to talk about that work today, because the constant coverage of the negative and the vitriol, assumptions, and attacks that follow that on social media take a toll. So I do want to emphasize and clear up just a final few things before turning it over to Erica and Lindsay. Our Family Service Division staff receive training in structured evidence-based decision-making to ensure that a child is only placed in DCF custody when it's necessary for the protection of the child. They do not make these decisions alone. They do not take custody without legal counsel, without court involvement and a court order. Our goal at DCF is to prevent child removal whenever it's safely possible. And when that removal is necessary, family reunification is the law, and it's our mission until that's no longer possible. So with that, I'll turn it over to Erica and Lindsay.
Thank you, Commissioner Winters. As Commissioner Winters stated, my name is Erica Radke, and I'm Deputy Commissioner of the Family Services Division of DCF. So I know we do have some time pressures. So what I'd like to do is we'll go ahead and start our brief slide presentation that gives an overview of our policies and our practices. And then we'd be happy to go ahead and answer some questions that the caucus may have. So moving to the first slide. This really provides the mission of the Family Services Division. And our goal is to make sure that children and youth in Vermont are safe from abuse and neglect, and that their basic needs are met, and to support youth involved in juvenile justice system issues to follow a more productive, law-abiding path. So FSD's aim is really to make sure that our child welfare mission is, while keeping the child and youth safe at home whenever possible with their family, because that's much less intrusive and much less disruptive for both the parent and the child if we can help a family that's struggling while the kid is there with their parents. But if that isn't possible and that the child can't be safe at home, we may need to petition the court for an order to bring a child into DCF custody. And that's generally foster care or kinship care, while at the same time, then parents are given supports and services with the ultimate goal of reunification, because whenever possible, we do want the family to continue to be reunified. But sometimes that isn't possible. And if that is the issue, then we do try to seek permanency for our children because they deserve safety, security, permanency. Really, all children deserve that. And we do that through options such as adoption or guardianship. So FSD has over 400 dedicated, hardworking staff in our division, and we have an operating budget in fiscal year 2024 of over $148 million. The structure of our division is really pretty straightforward. There are 12 district offices located throughout the state, and they serve as the base of field operations for our family services workers. There are also 2 statewide service units, the Centralized Intake and Emergency Services Unit, also known as CIES, and the Residential Licensing and Special Investigations Unit, known as RLSI. And then finally, there's Central Office, which is located in Waterbury, and that's where leadership is, and where the team provides support and consultation to the district offices, oversees policy and practice, performs data analysis and continuous quality improvement activities, manages budgets, grants, and contracts for the division, and maintains communication for our team with our federal partners. The primary function of FSD, one of the primary functions, is operating our 24-hour child protection hotline. And that's for intakes of reports of child maltreatment. And this is run by CEIS. That's the entity I mentioned earlier. Accepted reports of abuse and neglect are assessed and investigated by family services workers located in the district offices. And I want to point out that these family services workers do receive specialized training in doing investigations. Workers are responsible for engaging families for their goals to increase safety and lower risk, identify extended family and community supports. And that's really in order to build a network to assist the family that may be struggling in order to make sure that they have the care and support that they need. We also will seek court involvement when required to keep a child or our community safe. Now, when considering a report of child abuse or neglect, the governing statutes and policies that drive our work really dictate a simple question. It boils down to, is the child safe? And if not, what needs to happen to promote a safe environment for that child? So if a child does need to come into DCF custody, our work involves locating and supporting safe placement for that child. Therefore, FSD is responsible for licensing and regulating foster homes, residential treatment programs, and child placing and adoption agencies. And when appropriate, our work also does include exploring permanency options for children and youth needing safe, loving, and supportive forever homes. One of the unusual things about Vermont is that not only are we the Child Protection Agency, we also serve as the state's juvenile justice agency. So part of our duties do include supervising youth who are on probation for committing delinquent acts. But in working with these young people to promote law abidance, FSD takes a restorative stance. It's important to us that the youth take responsibility for their actions, that they make amends to those that they've harmed. But while at the same time, we use a strengths-based approach to really make sure that they are getting the help that they need in order to move on to a productive adulthood. So while the work that I described on these last two slides is our mission and it is what we do, I do want to acknowledge that this is not something that we accomplish all on our own. We engage with and have support and work alongside state service providers, federal agencies, community partners, as well as families and caregivers. And when we're all working together, that really is what we want to do to provide the best outcomes for our youth that are in DCF custody. So community members can contact the Child Protection Hotline at any time to report suspected child abuse or neglect. In 2024, CIES handled over 19,000 calls. The majority of these calls are reports that were made to the call center by mandated reporters, such as educators, healthcare professionals, and law enforcement personnel. So of those 19,410 calls made to the hotline last year, some 3,620 were accepted for assessment or investigation. And that means 19% of the intakes resulted in some level of DCF involvement. I'll turn it over to you, Nancy. I'm sorry, Lindsay.
Hi, everyone. My name is Lindsay Barron. I'm the Director of Policy and Planning for Family Services, and I am going to breeze through this slide. I understand it's very wordy and it has a lot of links in the event that anyone wants to do further exploration of the guiding statutes. What I will mention is that CAPTA, the Child Abuse Prevention and Treatment Act, provides the foundation of all front-end practices within child protection systems. And so there are required definitions of abuse and neglect that every state needs to comply with. CAPTA also is reauthorized every so many years, and there are provisions of CAPTA that speak to substance-exposed newborns, how child protection partners within the medical community to ensure that CAPTA notifications occur separate from a reporting path. When it comes to the ongoing side of child protection work, that's primarily held within the Social Security Act and Title 4E and 4B. And I will breeze through the rest. And FSD handles child safety matters through two primary guiding statutes. On the left-hand side of the screen, Chapter 49, that is what provides our definitions for categories of abuse and neglect. Those align with the CAPTA requirements that I noted on the previous slide. And on the right-hand side is a more general statute under Title 51 that provides the department to undertake assessments, make reports to the court, and generally assess situations as to whether a child is in need of care and supervision and potentially without proper parental care. So I provided a few examples on the screen there for how we do those assessments. Going back slightly to the centralized intake and emergency services intake data that Erica had talked about, we thought it might be helpful to walk through what happens when an intake comes in. And so what occurs is that central intake performs the first screen of that report. That's centralized, that occurs at a statewide level. That's something that is recommended across all states in the nation from the lens of reducing disparities or discrepancies across different regions, counties, and so on. And so we do have a central system. After central intake screens the report, it's then sent to the district for a second read. That's meant to be an independent screen of the report to assess whether criteria for acceptance is met. And if a report is accepted, we also have a differential response system. And so what that means is that there's not a one size fits all response. Not everything goes down an investigation path. And so whenever we have assessments, they are generally meant to be supportive, preventative in nature, assess whether the family might need support, resources, or anything that could help them overall. Whereas with investigations, they also are intended to be supportive, and we can make those same referrals, but there is a determination as to whether the abuse or neglect occurred at the end of, at the end of that. After a report is, after the track is assigned, it's assigned to a family services worker, and then the process begins. So this is a really high overview of the types of activities and the work that occurs when our folks are commencing an assessment and engaging with families. And so generally speaking, we will be in contact with the parent. We'll let them know about the report and what was alleged to have occurred, or what the alleged concerns are. Assessing child safety is always the first priority, first and foremost. So that might entail putting eyes on the child, speaking to the child, or conversing with the parent about the child and the home environment, or some of that depends on what the nature of the report was. So again, the children are always either interviewed or observed. There's always a home visit entailed. And often we are contacting collateral contacts, those known to the child who see the child potentially day in and day out and might be able to speak to any changes or anything that may be going on. So that might be school staff, that might be pediatricians, that might be someone that the parent recommends that we speak to, who can, share information or support. Within 24 hours of the report being made, so really within that first contact with families, we are using, so Chris had mentioned our structured decision-making tools. We are doing a safety assessment within those first 24 hours. And that is a tool that we use to guide our understanding of what danger is. And if there is a danger present, before we take any other action, we are we're proposing a safety plan with the family. We might do network building. We might bring in supports to the family. It might involve various check-ins or someone residing in the home for a brief period of time. After the question of safety is addressed, there is a risk assessment that we also utilize. And our risk assessment tool is intended to predict the future likelihood of maltreatment based on state data. And, excuse me. So for low and moderate risk cases, we're closing those cases. There's no requirement or really benefit to have further system involvement that's unnecessary. We also make referrals to the community prior to closing cases as appropriate or needed. If a case is high or very high risk, that's when we're offering voluntary family support services that we could help the family lower the risk and hopefully improve their circumstances. So whenever we think about a safety organized practice, this is integrated into our 5-year strategic plan. Safety organized practice is at the core of the work we do in terms of creating safety for our staff and for the children and families that we serve. And so this involves team decision-making, sharing those difficult discussions and plans. And so I had already mentioned the safety assessment. The first question there, or the question that the safety assessment assists us with, is whether the child can safely be in the home. This is also where we are safety planning, which I already mentioned. On the previous slide, there were a few bubbles about risk. That's the second bullet here of whether an ongoing case should be opened. If a case is opened, we are then doing ongoing risk assessments throughout the life of the case about whether the case can or should be closed. A few years ago, there was a UVM legislative study that was commissioned, And it was tasked with looking into our custody rates and what might be contributing to our higher rates of custody entrance compared to the general population. And one of the recommendations within that legislative study was really highlighting the importance of structured decision-making as a tool to reduce bias, to reduce subjectivity, and ensure consistency in understanding and decision-making across workers, across districts. And so we have geared some intentional efforts towards ongoing training. We've hosted 3 child welfare summits over the last 3 years in partnership with the Vermont judiciary, where we've had a range of stakeholders participating in those, from judges to state's attorneys to other parents' attorneys, children's attorneys, and our staff to really lean into our structured decision-making tools, how that influences the recommendations that we're making to the court. And we also produced a bench guide. It's a quick sort of one-page sheet to help on the bench and help with all parties in understanding what the key decisions are at every stage of the hearing. I know we're tight on time, so I'm going to speed through this. So often whenever we think about our system, we think about the fact that we are child protection. And when I think about the larger child welfare system, I actually think about everyone else that helps serve and support families in the community. And so, you know, that ranges across all disciplines, from prevention-based services, parent-child centers, economic and other resources, substance use treatment providers, mental health providers, medical professionals, and really, you know, natural supports and kin, neighbors, friends, those who, you know, every individual has someone that they would call if they were going through a hard time. And really what our workers are trying to suss out there is, you know, who can we bring to the table to support? And our partners are so crucial in this. As Chris mentioned earlier, our custody rates have been declining over the last several years. We credit this to the intentional efforts we mentioned around our structured decision-making, around intentional case closures, and continued effort and partnership with our judicial partners. And the last slide is just additional resources and references to documents.
Thank you so much. It was helpful to have that background information. And I think we'll open it up to questions, and go ahead, Representative Boslin.
Yeah, thank you for that presentation. So it feels really clear what your process is when you have a parent or a caregiver and children and an accusation and following through that way. What isn't clear to me is how this fits in if the child is still growing in the mother. So for example, can somebody make an accusation of child abuse when somebody's 9 months pregnant and drinking or experiencing opioid use disorder? And if that's the case, is the process the same or is the process different? You know, at what point does an intervention make sense in terms of looking out for the welfare of the eminent child as opposed to the mother's rights when the child isn't born yet? Because that part isn't clear to me at all from the slides.
That's a great question. And we had planned on honing in to talk about that directly because we know that's a big interest of many other people in the room. So I want to address it by just reminding everybody through the slides we were talking about, DCF is really a report-driven system. And, you know, we had this slide where we receive thousands of reports of potential abuse and neglect every year. And sometimes we do receive reports about a pregnant woman. And again, you know, our goal is really to avoid removal and to keep the child safe. So, and to do that, we need to have a timely prevention and to support the family during that critical time. So what we aim to do is to give supports and services for resources in advance in order to provide, you know, support before the time of birth. And that may involve sometimes having an assessment and connecting an expectant mother to supports and services. But per our policy, what happens is we may get a report about a pregnant woman and somebody feeling that there may be some maltreatment or something going on. But our policy dictates that we are not going to be looking at opening an assessment on that woman until 30 days prior to birth. So what we would do is take that intake and then hold it in advance, meaning not even screen it in or out until the time 30 days prior. And then that's when we would, our CIES workers would then look into the case to see whether or not it even needs to be screened in or screened out, and then open an assessment. And it's really, it's driven by policy. And the point is that if we can at all make sure during that time to give the mother what she needs, then we won't need to necessarily seek a court order to take a child into custody later if we can do these preventative services early on. And studies have shown really that that type of work is really far more successful and actually lowers the rate of having youth come into custody if we can get supports to the mom earlier. And it's a balancing act. We do recognize that having government come into a person's family is intrusive. So we do want to balance that with our mandate for helping and supporting families and children and youth. And that's a big part of why we're not opening investigations simply without all of the different structured decision-making tools that Lindsay mentioned, and also why we're not opening them right away where there's this long delay. And there have been instances where we may get several calls on mothers. And if we don't have information that warrants having a child assessment, then we don't open that assessment. And I just wanted to say too that in looking at our policies, we do have a focus on continuous quality improvement with all of our policies. And if we do find that a policy is not following the law or not appropriate for the needs of our families, we are absolutely dedicated to working and changing those policies that are inappropriate. And the last thing I want to say is that I've got a team of really dedicated professionals that do this work day in and day out, and their intent is always to help families, preserve families, reunify families whenever possible, and with the goal in mind of having safety for all of our children and youth in Vermont.
If I could add just a little bit more to that, Representative, I can imagine the criticism we would receive if we had information about a very dangerous situation, potentially dangerous situation that a child was about to be born into, and we said we should do nothing until that child is born. So I think this is our opportunity to, as Deputy Commissioner said, provide support, provide services, do an assessment before the emergent need arrives, and we aren't scrambling on an emergency basis to try to protect a child who's been born into some very difficult circumstances.
Representative Wood, thank you. I just want to concur with what the commissioner said at the outset about the job of the family services workers being among the most difficult in state service. I definitely appreciate the work that they do. My question centers around at what point would an individual know that there has been either a complaint registered, about them, and or that DCF is undertaking a review process, and ultimately they make a decision about an assessment or investigation. At what point does the person know about that?
Generally speaking, they would know that once we got a call and we started the intake process. If, let's say it's a medical provider that says this mother's been using drugs, we would reach out then to the family, to the mother, to anybody else that may have made calls about the situation. and then reach out to the mother to talk to them about the case. But as you know, all cases they vary. I can only talk in general terms. In certain cases, we may need to wait depending upon what would be best for the family. But generally they would be notified and to talk to sooner rather than later because we want to get the supports to help them sooner rather than later.
I guess, so I understand that. I'm a little confused by the part of your answer that said, that happens generally, depending upon the circumstances about what might be best for the family. And I'm just wondering how DCF would know what would be best for the family if they haven't actually talked to the person who the complaint is made against.
Generally, as they all start with whoever's making the report, and when we are doing that intake, we often ask about collateral individuals who have additional information about the case. And so it's sort of an information gathering, and that will dictate when the next step is to bring in and talk to the mother and reach out to her. But Lindsay.
So generally speaking, our policies require within 72 hours of the report being accepted that we're contacting the parent. And we refer to it as commencement, either seeing the child or reaching out to the parent.
So just love to get a little bit more specific about what I think we're largely here to talk about pregnant women rather than people who are already parents. So in that case, if they're only 4 months pregnant and you receive a complaint, in one scenario, I'm hearing you say you have about 72 hours to let them to inform them, generally according to your policies. But then in another scenario, I'm hearing you would wait until they're 30 days out from a presumable due date because you can't know the birth date. So if I'm curious what happens in that scenario. And then my other question I think a lot of us are interested in is where is the statutory authority for you to be protecting someone who's not born yet?
I think that when Lindsay was talking about commencement, that's different. That's the 72 hours. When a call comes in and it needs to be screened and then whether we're going to accept it or not. So they're simply being held in abeyance. And when the issue is that it's a pregnant woman until 30 days out, and that's when it will start that type of whether or not an assessment will be made. But in terms of the statutory process,
I can try to address the statutory authority. I think that's the subject of the lawsuit, and is something we want to be very cautious about talking about. And the pleadings are happening as we speak. There was a motion to dismiss yesterday that I think lays out some of that argument, and folks can go online and take a look at the legal arguments that are being made. We're confident that what we're doing is within the law. If a court tells us otherwise, we'll obviously change those practices. We're taking a very close look at our policies in response to any complaint we get, any lawsuit that we get. And if we need to change course, we will. But we're comfortable that being involved in a child safety matter before that child is born is something that we have a responsibility to do, that we have the authority to do. And we'd be derelict in our child protection duties if we received a complaint about an unborn child who's about to be born and we did nothing about it ahead of time. So there is a process by which we do, when we receive those complaints, we make sure we check in within 30 days to do that assessment, to potentially provide that support.
Thanks. I didn't mean to ask a question about the case. Earlier you mentioned something about CAPTA as, I think you said someone said it speaks to substance exposed newborns and that. So I'm just literally wondering what statute you feel that you have that working with women before they're working with women in a non-voluntary role where that. I'm just curious because I think we're just trying to understand from the legislative side where that falls. Is that federal or state statute?
I don't know if you're comfortable answering that, Lindsay, or not. I mean, it is a legal argument, but if you think you know the answer,
I think I would direct folks to some of the links in the last slide. There's a flow chart related to how Vermont complies with CAPTA and how we navigate plans of safe care for substance exposed newborns versus what needs to be a report.
And I'm not trying to be evasive, but I want to make sure we give the right answer and we can follow up with what the statutory references there.
Thanks. Representative Burke.
Thank you. Do you take into account in terms of considering risk for child, the housing status of the mother?
Can you say that a little louder?
Sorry. In considering the safety of a child, you consider the housing status of the mother. You know, I mean, obviously you'd be concerned about drugs or alcohol or something like that. Would you also consider would that lack of housing be a factor?
Yeah.
So being unhoused alone within itself is not considered a danger. It is considered amongst a multitude of factors that are going on for the family.
Representative Howard.
Thank you. I just want to say quickly that I worked in the state's attorney's office in Rutland. DCF was located in our building, so I'm a little bit aware of what everyone does. And I just want to say thank you so much for everything that you do. Your social workers are just amazing. I have a constituent who's a social worker. The situations that they get put into are just sometimes horrific. And I had a situation that was brought to me by someone of a child who was being mistreated, and along with teachers who verified, brought the case to DCF, and thank God that child was removed and hopefully put in a happy home. I also am curious about the juveniles. Where are you meeting them? Where are the social workers meeting them? And also, is there law enforcement that goes with the social worker to a home, because it can be really dangerous?
Thank you. And thank you for what you said about our workers. I mean, I'm proud of them. They do a lot of difficult tasks. In terms of juveniles, and you asked where are they placed, or
When you meet with a juvenile, where are you meeting with them?
you know, it all depends on, each situation is different. So we have workers that meet juveniles, like let's say juveniles that are with their juvenile justice involvement, they go to their residential placements, or it may be just outside at a park. It all depends on where the juveniles are and what's comfortable for them and safe for everybody. So there are many settings where we can meet. Our main focus is making sure that we're meeting with them regularly to get a good read on how they're doing, and making sure that whatever placement they're in, such as if they're in residential placement, if they're doing well, that they can move to a less restrictive placement.
I have one question, and then I want to take a question from the audience from Esther. So I'm just wondering if I've heard a couple of terms: pregnancy docket, high risk pregnancy list, pregnancy calendar. So I'm wondering what this group of people would be what is the term that's used within DCF?
Mhm.
How many people are in that group, roughly, from, an average maybe? And what sorts of complaints would get a person added to that list?
I guess I want to back up and make sure everybody knows, when sometimes it's come out in the media that we're sort of surveilling women or having a tracking calendar, and that's not really what this is. We don't broadly track pregnancies. What happens is, if we do get that call from somebody in the community saying that this pregnant woman may have some difficulty, we're putting information in an Outlook calendar. That information is simply, and this is generally speaking, their initials, the intake number, and the due date. And it's really just to sort of keep track of when we need to do that additional reach out. And it's really a follow-up calendar because not only are there issues about pregnant women on that calendar, we've had parole officers call us to say someone may be being released at a certain date and that maybe we should be reaching out to the family to discuss some type of safety plan. So that information too, since we have a specific date that we need to go back to refer them to, is on that calendar as well. And it's simply a couple of people, a couple of workers have access to the calendar, and then we'll reach out to workers for individual cases if the cases are screened in, have them then reach out.
And so can you offer a few examples of what would trigger DCF's involvement with pregnant women? What types of complaints? I know it's been mentioned, substance use disorder and then Molly's question about housing. And I know I heard you say that alone would not be enough, but what kinds of things could be brought up in a complaint that would have that person added to the list to watch?
Primarily substance use, but can you think of any other general issues that have?
So it's primarily substance use, and then there are also parental capacity concerns. If there was a recent termination of parental rights and the circumstances related to the TPR have not changed, for instance. Our screening policy is available online that outlines those examples and the screening guidance.
Okay, thank you. Esther, you want to go ahead?
Yes.
Close this out?
Hey, all, I want to say as a former administrator, I have made those calls and I thank you. And I've seen some hard situations and I only got a glimpse of the work that you all do. So thank you so much for your work, for thinking about our children. And I also understand this is a hard line. My question today is, who is DCF allowed to share pregnancy-related data with? And are there any legal or privacy constraints regarding the sharing of this information? Thank you.
We generally, with these types of cases, we have to be so careful not to violate our clients' rights. We aren't able to release anything specific at all. We want to respect the people we work with. I think general information we're able to talk about, like numbers, and without attributing it to specific people or specific cases.
So we're federally required to report annually, broadly, obviously not client-specific information, but about substance-exposed newborns and what our CAPTA notifications look like year by year.
Any final questions? Take one.
I'm sorry, did you say Outlook calendar or I just?
Yes.
Okay. How many people are on it?
I don't have that number offhand. I would have to find that.
Also, just to clarify, it might not be a person-specific matter. It's intake numbers that are on it. So there might be multiple reports about a single family.
That's an excellent point. So there may be multiple calls about an individual that come in from people with concerns, and that would be on the calendar. And like I said, the calendar does have follow-ups on other issues as well.
My question about the social worker being accompanied by a law enforcement officer, does that happen?
Particularly when there are cases where we are aware if there may be danger, or if there's going to be a removal, we do like to have law enforcement there with us to protect our workers.
They're not there all the time.
So Chapter 49 outlines specific circumstances of reports that we're required to notify law enforcement and partner with them. And we're so appreciative of our law enforcement partners. And, both from a child safety lens and a staff safety lens, they're just truly invaluable in our work, and we're so appreciative. But I would say there's some variation throughout the state, just based on capacity and resources. within various law enforcement agencies. And so I think in larger areas, they're less able to go out on more cases. Whereas in smaller communities, sometimes they're able to have that partnership with them.
Thank you.
So just one more quick, I think it's a yes or no, but I'm processing this information and this came up. So when a woman is added to the Outlook calendar, the list, or and hits that 30-day free delivery date mark, is she the first person is she contacted? Is she is that how the process starts?
That's where the screening will start. Generally, that's where the CIS will open up the screening to see whether or not they will even accept the case
Okay.
to move forward. And then
Starting with the woman who's at the center of the complaint.
generally starting with who the reporter was that called, and then it goes from there.
Yep. Okay. Thank you.
We need to,
Sorry, one more. And so then you do that, you talk to the reporter, you decide to open, and then your policy, your procedure is you would connect with that woman and offer supports.
Generally, yes, that's our policy because it is a support base. It's not a punitive thing at all.
I just feel compelled to say every case is different. Every case is extremely complicated. We're trying to do what's in the best interest of protecting children. And so there may be some variations from policy from time to time based on this.
I need to wrap us up. I know there's more questions probably now, just given a lot of good dialogue and information. So just really want to reiterate our great appreciation to DCF, not only for coming today and being willing to have this conversation, but also for the incredibly important work that your team does and that's been expressed here today. I think you wanted to offer.
Just very quickly, thank you for the opportunity. We really appreciate being able to talk about our work and give some praise to our workers, and thank you all for doing that as well. If anyone has any follow-up questions that we weren't able to get to today, please feel free to contact any one of us. Email will probably work best. And I think you could find us, Chris.Winters at Vermont.gov. Thank you all.
Thank you very much. I appreciate your questions.
Thank you. Thanks everyone for being here.